constitutional remedies under Article 32. So, the right to remedies for enforcement of fundamental rights of the aggrieved person. When my fundamental rights is not enforced or it is abridged. When my fundamental rights is not enforced or it is abridged, the aggrieved person, aggrieved citizen, he must be an aggrieved citizen, right? The aggrieved citizen can ask the Supreme Court under Article 32 for right to remedies for the enforcement of fundamental rights of an aggrieved citizen. The right to get fundamental rights protected is itself as a fundamental right. So, when fundamental rights are not implemented, we have Article 32 to implement fundamental rights. Article 32 in itself is a fundamental right. Dr. B.R. Ambedkar says that Article 32 is the heart and it should soul of the Constitution. Heart and the soul of the Constitution, the most important article. Supreme Court has stated this as a basic structure. So the Supreme Court has stated this as a basic structure. Hence, it cannot be abridged or taken away by an amendment to the Constitution. This Article 32 is a basic structure. Now, what are the provisions under Article 32? Right to move to Supreme Court. We are moving to Supreme Court for the enforcement of fundamental rights. When we move to the Supreme Court issues writs to enforce the fundamental rights. We move to the Supreme Court to enforce fundamental rights and to enforce the fundamental rights, and the Supreme Court it issues the writs to enforce the fundamental rights. Parliament can empower other courts to issue the directions, orders, writs of all the kinds without prejudice to the powers conferred on the Supreme Court. So the Parliament is the one which can empower. Parliament is the one which can empower. It can empower other courts. So the Parliament can empower other courts to issue directions. The courts are going to issue the directions, order, or writ. It can issue the direction or it can issue an order or even the writ for the enforcement of the fundamental rights without prejudice to the powers conferred on the Supreme Court. This is without any prejudice. We have the powers are conferred to the Supreme Court. Does not apply to the High Courts. So this is not applying to the High Courts as they have this power already under Article 226. Other courts except High Courts. The Parliament is empowering other courts to issue the orders, writs, directions, right? This is for other courts except High Courts because the High Courts are already having this power under Article 226. The right to move to the Supreme Court shall not be suspended except as otherwise provided by the Constitution. So the Constitution states that the President can suspend the right to move to the Supreme Court. The right to move to Supreme Court. It gets suspended during a national emergency. The Constitution is providing for the right to move to the Supreme Court. The High Court, the Supreme Court alone. So the Parliament is empowering other courts is done by the Parliament, and suspending these right to move to the Supreme Court is provided by the Constitution. The Supreme Court is given a position of the defender and guarantor of the fundamental rights of the citizens. Supreme Court need to defend and it also need to guarantee. Defender and guarantor. So defender is it as a defender and then we have it as a guarantor of the fundamental rights of the citizens. Now, what is the purpose of Article 32? It is guaranteed, and then we have effective, expeditious, inexpensive summary remedy for the protection of the fundamental rights. It can only enforce the fundamental rights which are guaranteed in the Constitution and not any other rights. Only those fundamental rights, only the fundamental rights is guaranteed under the Constitution and it cannot enforce any other rights. To enforce fundamental rights, the Supreme Court, the original jurisdiction is Supreme Court, but it is not exclusive since high courts can also enforce the fundamental rights, but citizens can move directly to the Supreme Court as well. Supreme Court has ruled that where relief through High Court is possible, aggrieved parties should first move to the High Court. We have the types of the writs in 32 and High Court in Article 226. Article 32. The Parliament can empower again any other courts to issue writs. No such provision is made yet. Difference between writ jurisdiction of the Supreme Court and the High Court. This is original jurisdiction. Now, the Supreme Court can enforce fundamental rights only, but the High Courts can enforce the fundamental rights whether and also the ordinary legal rights. So the Supreme Court can enforce the fundamental rights only, whereas we have the High Courts can enforce even the ordinary rights as well. Ordinary legal rights as well. So the Supreme Court is against the persons or the government throughout the territory of the India, and High Court is against the person within its territorial jurisdiction. Here it is to be noted that when you are approaching Supreme Court, anybody, any person or government, even the government throughout the territory of India, right? Whereas when we are approaching the High Court, this is against the person or the government within the territorial jurisdiction, only outside if the cause of action arises within the territorial jurisdiction. The Supreme Court cannot refuse to exercise its writs jurisdiction as remedy under Article 32 is fundamental right and High Court the writ jurisdiction is discretionary. The Supreme Court first it cannot refuse to exercise the writ jurisdiction as remedy under the fundamental right, but High Court can refuse. Supreme Court is thus constituted as defender and guarantor of the fundamental right. Now, the first one is habeas corpus. Habeas corpus is the Latin term which is to have the body of. We are having the body of. So, what is habeas corpus? It's a Latin term. So, it is Latin or Greek, Latin term. Habeas corpus means to have the body of. The order by the court to a person who has detained another person. One person is detaining another person. Detains another person, right, to produce the body of the latter before it. The court then examines legality and the cause of detention. The court is to then examine the legality and then the cause of detention. This writ is a bulwark of individual liberty against arbitrary detention. So it is a bulwark of liberty, individual that to the individual liberty against whenever you are having an arbitrary detention, right? It is a bulwark of the individual liberty when you are having individual liberty against arbitrary detention. This is arbitrary detention. It can be issued against the public authorities and private players, individuals as well. So this is issued against the public authorities and private individuals as well. Right. Not issued if the detention is lawful. Proceeding is for the contempt of a legislature or a court. This is or a court. When they are detained for the contempt of a legislature, or they are detained for the contempt of a court. And the detention is by a competent court and the detention is outside the jurisdiction of the court. In ADM Jabalpur versus Shivakant Shukla case, Supreme Court ruled that a person's right to not to be unlawfully detained, habeas corpus can be suspended in the interest of the state. Right, not to be unlawfully detained, that is, habeas corpus can be suspended in the interest of the state. So, what is the point we have to note? Habeas corpus. We have habeas corpus, right? It can be suspended. Can or cannot be suspended? It can be suspended. When? In the interest of the state. So habeas corpus is suspended in the interest of the state. Now what is prohibition means forbid. You are prohibited to enter this place means you are forbidden to do something. This is only by a higher court to a lower court or even a tribunal. Right? This is only by a higher court. Only for the courts we have CP. Only for the courts. Prohibition is only for the courts, right? Issued by a higher court. This is to a lower court. A higher court is issuing to the lower court or a tribunal. Prevents the lower courts or the tribunals from exceeding the jurisdiction or usurping a jurisdiction that does not have. When the courts are exceeding the jurisdiction or it is catching a jurisdiction which it does not have, does not processes direct inactivity. Mandamus is going to be like direct activity. This is direct inactivity. Not available against the administrative authorities, legislative bodies, private individuals, or anybody. This is only the court. Now, certiorari is to be certified. Issued by the higher court to the lower court or the tribunal authorities affecting the rights of the individuals but not against the legislative bodies, private individuals. Right. Now, this issue is certiorari is just stopping a court. Prohibition is nothing but forbidding a court. Certiorari is also for the courts when issued by the High Court to the low court, tribunal, or administrative authorities. Here we have two things for related to the courts. The first one is prohibition, and the second one is certiorari. Prohibition and certiorari are for the courts, right? Only for the courts. This is to the lower courts, tribunals, right? This is to the courts as well as the administrative authorities. This is for transferring the case. Certiorari includes the transferring of the case. Or other hand, squashing the case, squashing the order. Transfer or for squashing. Certiorari is used for transfer or squashing. Prohibition is used for like you should not do it. But what if the court, a lower court has issued a order, right? First they have to go for certiorari. They have to squash this order. Then they have to forbid the court from participating in further proceedings, right? Either you have to transfer, this is related to transfer or squashing. This is related to the jurisdiction. When they are crossing the jurisdiction, this is not related to jurisdiction, but it is related to transfer a case which is pending in the lower court or to squash the order of the later. It is both preventive and curative. Prohibition is only preventive. It is not providing a cure. For example, preventive and curative is we are squashing the orders, right? So in prohibition, you don't squash a order. You just tell that this is not your jurisdiction. But what if they have issued some orders? There is no squash for that order under prohibition, right? So we'll be having that certiorari is both preventive and curative because they are transferring the case as well as squashing the order as well. But prohibition is only preventive. You can only prevent it. Mandamus is we command you to perform your official duty. So here it is mentioned that mandamus means direct activity. You directs the activity, but prohibition directs inactivity. You are forbidden to do this thing, right? So mandamus is we have seen certiorari. Now mandamus and then q warranto is lost. Mandamus and q warranto is for public body, inferior court, even the court, tribunals, government for the same purpose. Right. Now this is a public official. Even the inferior courts are coming under the mandamus and tribunals are also coming under the mandamus. to do your work. We command you to do your work which you have failed to do. Whereas certiorari, we are stopping you, transferring you as transferring the case as well as quashing your order. Prohibition is you are forbidden because you exceed your jurisdiction. In mandamus, it means we command. We command mandamus. Commandamus. We command. Right. We command and then we have the mandamus. So we command mandamus, and then to a public official asking him to perform his duties, official duties that he has failed to or he has refused to do. We are asking a public official to perform his official duty that he has failed to do or refused to do. Perform or against a public body, corporation, inferior court or a tribunal or government for the same purpose. Cannot be issued against a private body or an individual. Right. To departmental instructions without statutes force for discretionary duties for to contractual obligation against the president or the governors or against chief justice of the high courts in acting in their judicial capacity. So who does mandamus apply and who it does not apply is again important. To perform or against a public body, corporation. A public body, inferior court is also coming over here, tribunal or the government for the same purpose for the mandamus, right? Because inferior courts, if they are not acting, it tells them to act. It cannot be issued against a private individual or a body against the private to enforce the departmental instructions without a legal force, and if they are doing something discretionarily to enforce a contract. This is important to remember, to contractual obligations. So this is important to remember. So what is important to remember? Contractual obligations against the president of India or the state governors, against the chief justice of high courts. Q warrant, or by what warrant you are sitting here, the court, to inquire the legality of claim of a person to a public office. The legality of a claim. Legality of a claim. Legality of the claim of a person to a public office. It prevents illegal usurpation of public office by the person. It cannot be issued against ministers or private office against substantive public office of permanent character created by the law. Can be sought by interested person and not necessarily by the aggrieved person. Now for armed force, we have Article 33 is for the armed force. Now martial law versus national emergency, and Article 34 is restrictions on fundamental right while martial law is enforced. Article 34 is with related to the martial law, and Article 35 is who are having the power to make laws with respect to the fundamental rights, right? Then we have to see right to property. What happened to right to property and exceptions to right to property, and some fundamental rights which are outside the jurisdiction of fundamental rights. Now 33 is for armed personnel, right? Armed forces and their fundamental duties. We have the armed persons. So what is forces and their fundamental rights? The fundamental rights of the armed forces. So we have the armed forces and the fundamental rights of the armed forces. Article 34 is related to the martial law. Article 35 is with respect to who can make laws for implementing fundamental rights. Article 33 is armed forces. Parliament can restrict, we are restricting or we are abrogate, completely cancelling the fundamental rights of members of, this is like armed forces. From armed forces, you are coming, then we have the paramilitary, police, intelligence agencies, So, for armed forces, we have the armed forces. For the paramilitary forces, we have even paramilitary forces. Police, we have the police forces, intelligence agencies, and analogous forces. Only the parliament can make such a law. So, who can make such a law? Parliament alone can make such a law for abrogating the fundamental rights. Laws cannot be challenged in the courts on contradiction of the fundamental rights. Such laws can even cover the non-combatant. Combatant is a military or a armed person. Combatant. Combatant. Now, such laws even apply for employees of the armed forces, like the barbers, even for the cooks. Laws can exclude court martials from the writ jurisdiction of Supreme Court, High Court as far as the enforcement of fundamental rights. So, writ jurisdiction of the Supreme Court and the High Courts covers lower courts, and then we have the tribunals as well. But we have the court martials are excluded from the court martials are excluded from this writ jurisdiction. A law made by the parliament can exclude the writ jurisdiction of SC and HC of the court martials. Now, what is a martial law versus the national emergency? Affects not only the fundamental rights, national emergency affects not only the fundamental rights, as interstate relation is being affected, distribution of the revenue and legislative powers are changed. So the center state is related to the administrative, revenue is related to the financial, and legislative is related to the like legislative powers, right? Everything administrative, financial, and legislative powers, center state relations entirely disrupting during the national emergency, whereas during a martial law, it affects only the fundamental rights. The fundamental rights are alone affected during the martial law, whereas during the national emergency, it affects not only the fundamental rights, center state relations, distribution of the revenue, and legislative powers. It suspends the government and the ordinary law courts. So the government is suspended and ordinary law courts are suspended over here. Continues the government and ordinary law courts. So affects only the fundamental rights. It does not affect the center-state relations because the government itself is suspended over here and ordinary law courts are even suspended over here. And the government and the courts are not suspended over here. Instead of suspension, they have few affected in their relations, right? But the entire government is suspended, imposed in some parts of the country. It is imposed in the whole or part of it. Now, no specific provision in the constitution. It has a detailed specific provision with related to the martial law. Restrictions on the fundamental rights when the martial law. Now, related to martial law, we are not having a separate chapter. It is just mentioned that there are restrictions on the fundamental right when martial law is enforced in any part of the country. Parliament can indemnify any government servant or any other person for any acts done by his or her connection with the maintenance of restoration of the order when martial law is in force. Right? You should not try for the maintenance of restoration of a order. Parliament can validate any sentence, passed, punishment inflicted or for forfeiture ordered or act alone done under the martial law in the such area. Martial law is not defined in the constitution. Martial law refers to a situation where civil administration is even run by the military. During the operation of martial law, the military imposes restrictions and regulations on the rights of the citizens, can punish the citizens, and even condemn to the death. The Supreme Court declaration of the martial law does not automatically mean the suspension of the writ of habeas corpus. Even if martial law is in place, it does not mean automatic suspension of habeas corpus. Now, Article 35 means that laws lay down, Article 35 lays down that the power to make the laws to give effect to the certain specified fundamental rights shall vest only in the parliament and not in the state legislature. Ensure uniformity throughout the India with regard to those fundamental rights. Parliament shall have the power to make laws with respect to the following matters as Article 16 is opportunity. 32 is writ jurisdiction, empowering other courts to make writs. 33 is armed forces restriction. 34 is with related to the indemnifying the government servant or any other person for the acts done during the operation of martial law. Only parliament and not the state legislature under Article 17, untouchability, traffic in human beings and forced labor. Now we are going for right to property. Initially it was 31 article. It was deleted by the 44th Constitutional Amendment Act of 1978, and 31A is inserted, 31B is also inserted, and 31C. These are restrictions on the fundamental rights. And this same 44th Constitutional Amendment of 1978, it inserted a new article, is Article 300A. This is under the right to property. Originally, the right to property was dealt in two articles, Article 19(1)(f) and then we have Article 31. Article 19(1)(f) and then we have Article 31. Right. Article 19(1)(f) and then we have Article 31. 44th Constitutional Amendment Act has abolished the right to property. Inserted a new article is going to be Article 300 under the right to property. According to Article 300A of the Indian Constitution, no person shall be deprived of his property save by the authority of the law. There can be a law to deprive a person's property. As mentioned in the Constitution, it is a constitutional and legal right. It provides that no person shall be deprived of his property except by the authority of the law. Right to property remains a legal right or a constitutional right. It is not a part of the basic structure. Right to property held that the citizen's own right to property is a human right and the state cannot take possession of it without following due process of the law. It referred to the verdict in state of Haryana versus Mukesh Kumar case in 2011, where it held that the right to property is not only a constitutional or statutory right, but it was also a human right. So, right to property is not a constitutional, and then we have the statutory right, but it is also a human right. The state cannot trespass into the private property of the citizens, then claim ownership and then land in the name of adverse possession. What are certain exceptions to the fundamental rights is Article 31, Article 31A, Article 31B, and Article 31C. Article 31A saves five categories of the laws from being challenged and invalidated on the grounds of contradiction of the fundamental rights, and Article 7, the rights of estates. Related rights, estate. First, then we have taking over the managements of properties by the states. Management of a property, it is taking the right to manage a property, right? And amalgamation of the corporations, extinguishment or modification of the rights of the directors and shareholders of the corporations. It does not immunize the state from judicial review unless an act under this has been made reserved for the president's consideration, and it has to be receive the president's assent. So in Article 31A, we are going for the rights of the estates. First, the rights of the estates, then we are going for amalgamation of the corporations, amalgamation of the corporation, then we are having the shareholders rights, and you are in itself taking the management of property. This amalgamation and shareholders right is related to corporations. So there's amalgamations, and then we have the shareholders right is related to the corporations. Then management of a property. We are going for the management of a property, right? Now the estates, it is related to the estates, and then we have the property, the managing the property itself, and the amalgamation of the corporations and extinguishment or modification of the rights of the directors or shareholders of the corporation. It does not immunize the state from the judicial review unless the judicial review is not there, but and this act must get the president's consideration. Compensation is the market value when the state acquires a land held by the person under personal cultivation and the land is within the statutory ceiling limit. This is the statutory ceiling limit. 2 acres, let's say example is 2 acres. If the state is acquiring this land as well, it should give market compensation. This is for personal cultivation. If this land is for his personal cultivation, it should give him market value. Then we have Article 31B, saves acts regulations in the ninth schedule from being challenged and invalidated on the grounds of contradiction of the fundamental rights. Scope of Article 31B is wider than this is only for four matters, but here we have the scope is wider than Article 31A. There cannot be a blanket immunity from judicial review. The judicial review under ninth schedule is a part of the basic structure of the Constitution, and laws under the ninth schedule after the 24th April 1973 are open to the challenge in the courts. Now, this is inserted by the 25th Constitutional Amendment Act of 1971. So, Article 31C is inserted by the 25th Constitutional Amendment Act, whereas the ninth schedule is by the first Constitutional Amendment Act, Article 31A and 31C. The law, no law can seek the implementation of no laws that seek the implementation of the socialistic DPSPs under Article. We have DPSPs under Article 39B is going to be a common resources must be distributed for the common good. And 39BC is related to accumulation of wealth. If it is violative of the fundamental rights, Article 19 and 14. Here we also have fundamental rights violative of Article 19 and 14 estates, management of the property, amalgamation and then modification of the rights of the shareholders or the directors in the corporations. Now we have no law containing the declaration that such effect. This is actually accepted, but the 42nd Amendment tried to extend the first part of the article to include all the DPSPs, but this is meant unconstitutional and invalidated by the Minerva Mills case 1980, which laid a balance between the fundamental rights and DPSP. Rights outside Part 3 is constitutional rights or legal rights or even non-fundamental rights. No person shall be taxed. No tax shall be collected except by an authority of the law. In Part 12 of the Constitution, Article 265, no tax, we say that no tax is even levied or even collected except by a law, authority of the law. This is in Part 12 of the Constitution. Then the same part 12 we have Article 300A is no person shall be deprived of his property except by the save by the authority of the law. 300A in also in the part 12. In part 12 also related to the taxation 265 300A, then 301 is trade, commerce and intercourse throughout the territory of the India shall be free. In part 13, this is related to the voting. Voting rights is in the part 15. Now Article 301 we have Article 301 and Article 326. Trade, commerce throughout shall be free. So part 12 is the tax and then we have property. For the tax we have Article 265 and for property 300A. 301, this all are in the part 12. Is part 13, right? This is trade, commerce and intercourse throughout the territory of the India. Article 326 is the right to vote is an important constitutional right. However, Article 326 part 15 of the Constitution provides universal adult franchise but does not specifically mention the right to vote. It mentions it as a universal adult franchise, but there is no right to vote. It does not mention right to vote. In case of the violation, the aggrieved person can move directly to the High Court under Article 226 of the Constitution.